May I be your lordship? Lordship, I beg to mention item number 11. The matter may be adjourned for the day, your lordship. Let the matter be published.
Supplementary first item number 70.
Wait, please, your lordship.
Yes, ma'am.
Lordship, yesterday your lordship had queried my lord regarding the name of the petitioner's father, my lord. There was an affidavit on 11/3/2019, my lord.
The whole law laid down by the honorable.
Yes, my lord.
Anything else?
And my lord, father, my lord, I have to submit, my lord, regarding petitioner's mother, my lord. There is page 6, paragraph 9, my lord. Because petitioner father expired, my lord, so she was known as a Kamla Beva, my lord. Yes, my lord. And father,
Whose wife?
my lord, wife of my lord, Abdul Hussain alias Abul Mia. Matlab she-
Not your details. You have yesterday read the details.
Yes, my lord.
There is no mention. You have specifically mentioned that your father is late Abul Mia.
Yes, my lord.
Mention of Abdul is not there.
My lord, later on affidavit has made, my lord.
That will not help you.
Yes, my lord. And my lord, one citation, my lord, that is regarding nationality determination, my lord.
What is the citation?
That is, my lord, Air Online 2019 SC 541.
Sirajul Bhau.
Yes,
Sirajul Bhau.
yes.
Yes, what is the proposal?
My lord, regarding the name, my lord, there.
When in this particular judgment you are correct. The thing is this,
Yes.
why the honorable apex could consider this matter? It was earlier rejected by the tribunal, rejected
Yes.
by the division bench.
Yes, my lord.
Then when the matter to honor the Supreme Court, why did you
Considered, my lord,
why?
my lord, paragraph 3. Yes, my lord. We have heard learned counsel for both sides extensively and have gone through the documents produced by the appellant ourselves. On perusal of the same, we find that a number of documents have been relied upon by the appellant, starting with a voter list of his grandfather, Kamatullah, in village Sotabasi Jajani. There is no doubt that the great-grandfather name Amutullah appears as Amutullah throughout the documents. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found is that some of the documents, Kafatullah later becomes Kamatullah. However, what is important to note is that his father names Amutullah continues as Amutullah and the other family members associated continued as such. Also produce our NRC registration details in the year 1971 of the grandfather who is noted to be Kafatullah in this document. Other voter lists are then produced where the letter F becomes the letter M, with other family names remaining the same. In fact, the appellant has himself produced the document of 1981 from the Income Tax Department giving his permanent account number. Apart from these documents, certain other later documents have also been produced, including photo identity cards issued by the Election Commission of India and identity card issued to his brother, including voter list in which the appellant's name appears. Having gone through these documents, we are of the view that it is not possible to state that Kamatullah is not the same despite being named Kafatullah in some of the documents. This being so, the grandfather's identity, father's identity, etc. has been established successfully by the appellant. Further, the mere fact that the father may later have gone through another village is no reason to doubt this document, my lord.
So what is here? What is here?
My lord, this is only, my lord.
So
My lord, my lord, and again, my lord, yesterday I have received one NRC documents, my lord, that
you now we are here to decide whether the order of the capital is
yes,
look the scope that is here.
yes, my lord.
Now reading the result of the tell us how to be applicable here.
My lord, only, my lord, that that the place they have changed, my lord.
Not
Only.
only that. Your case is that you have a federal list of 1956.
Yes, my lord.
Where the name of the
Yes.
What was the name of your father?
My lord, Abul Al,
You have also protected that Komala Beva is your
mother.
now. Komala Beva is wife of
Abdul Hussein, as well as Abul Mia, my lord. Same, my lord.
that is your brother because it has documents.
Yes, my
You will show. Secondly, there is no document to show that Abul Mia is Abul Ali.
Yes.
From your written statement, it is very clear. But you have not stated when did he expire, what happened, why only the release of 1966 is limited? In which year, the name of your mother figured in the voter list? Which year? The voter list of 1966, name of your mother is not there, right?
My lord, Kamla Bibi, my lord. That time her husband was there, my lord.
Right. It was Mola Bibi.
Bibi.
From which place? From village number 5, Nangoli.
Yes.
Then what happened? That is in 1966.
Yeah.
So if it is 1966, just tell us, after 1966, where is the voter list of 70, 75, 79? Go to there are parliamentary elections, there are legislative elections. What happened after 1966? Must able to establish your case.
Yes, my lord.
Which year they have left number 5 Nangoli? Which year?
That has not been mentioned, my lord.
What you have stated in your written statement as you have read yesterday. You have not mentioned when did your parents had the form number 5 Nangoli to Bagpuri.
Backward.
You did not mention.
Yes.
Then you are also silent whether the name of your mother was there in the April list of 1970 or thereafter. In 2013, as per the documents that you have annexed with your written statement, 45, your mother was 58 years in 2013. So if it is 58 years in 2013, what will be her birth year? Can you make out? What will be the birth year? When did your father expire? Have you mentioned?
Page 30, Lord.
No, that is mother's.
Oh, yes, yes.
Otherwise, name of your mother, father, along with your brothers, would have been in the voter list. There is no nothing before the preference. You say earlier you married to one Doinala. That is why the EPIC is in card, is in the name of, but that is in your name as also reflecting name of your earlier.
And
But if you see, it was issued in the year 2013,
again, yes, my lord.
where in your own written statement you have said that in the year 2006 you got remarried with another person.
Yes.
So how can it be possible? In 2013, the EPIC will be. When did you vote with Doinal Abedin? Which year?
Journal, my lord, 2001.
Where is your voter list? Have you exhibited that before the tribunal? Now we ask you that the age of your mother for the EPIC was 58 years in the year 2013. So what was her birth year? 2013 minus 50.
1955.
90. Now please come to page number 16 of your petition. not, it is your part. Page number 26 or 25. The voter list of which year?
This is, my lord, 71,
Voter list of
71 or 66.
60. What is the age of your projected mother?
Like 23, my lord.
20. 1966 minus 23. What was her birth year?
1943, my lord.
1943. 66 minus 23. 43, so 1943. So there is a vast difference between 1943 and 1955.
Yes.
How do you expect the same lady? After 1970, page 28. Name of your father was not reflected in the voter list from number 5, normally. And you could not connect any such voter list or voter place before the tribunal. But what are the exhibits that you have placed before the tribunal? Come to page number 38. The evidence.
Yes. Certified copy of voter list 1966, my lord. And my lord, where OP's parents' name appeared, so and so. And the number 2 is the elector photo identity card in the name of OP's mother, Kamla Bewa. And exhibit 3 is the another elector photo identity card of OP Lalbanu Nesa. And exhibit 4 is the Kabin Nama. And exhibit 5 is the family ration card.
Oh.
And next are 1 Malad Panchayat certificate.
But it was not proved.
Yes, ma'am.
The marriage certificate also, the Kabinama has also not been proved.
Yes.
Right?
Yes.
So how you have established for the tribunal? What is the illegality if the part of the tribunal is not considering you?
Only, my lord, without verifying the documents, my lord.
Who verified? Who have to prove it?
My lord, the issuing authority, my lord.
Whose fault? Who is supposed to do it?
It is
It's
Count-
whose duty? Yeah. Anything else you'd like to add?
no, my lord. This is fine.
Yes, Mr. Sharma. What we have.
Lordship, opinion is very much clear, Lordship. Page 39, Lordship. Yes, Lordship. Exhibit 1 is the certified copy of voter list of 1966, where one Abul Mia, son of Faiz, aged about 28 years, shown as her father, and one Kamala Bibi, wife of Abul, shown as her mother, and their names appeared in the voter list of 1966 under 71 Rangamati SCLSC at village number 5 Nangoli Muzar Rangamati PS Bangoldoi district Dorong Assam, but cross of the OP as DW1 on which she admitted and produced exhibit 2 elector photo identity card of mother by number so and so. Her mother's name Kamala Biwa, aged about 58 years. Her father's name Abul Hussein. That names of Opi's mother was born sometime in the year 1955. Then Opi's mother's age was 12 years in the year 1966. If we contrast with the certified copy of voter list of 1966, that is Exhibit 1, then we found that Opi's mother's age was 12 years in the year 1966. It is not possible that one minor girl had casting vote at her 12 years age. As per Exhibit 1 produced by the OP1 Kamala Bibi, casting her vote at her 23 years of age. Lordship has already pointed out these things, Lordship. Other hand, in the case of her father's name was also recorded as Muhammad Abul Hussein. That means her father's actual name is Abdul Hussein. Here it is clear that OP projected her father as Abul Mia, son of Faiz, and also projected her mother as Kamala Bibi to suit her purpose, and they are different persons from different family. The OP had also failed to establish that Abul Hussein and Abul Mia is the same and one identical person, that is her father, and Kamala Bibi and Biwa and Kamala Bibi is same and one identical person, that is her mother. Moreover, OP had failed to establish linkage with her father, that Abdul Hussein was son of Faiz. Thus, it can be safely presumed that due to discrepancy of the name of her father and mother, it is clear that OP had projected one Faiz as her projected grandfather, one
Abul,
and one.
Abul Mia.
Yes.
Abul Mia.
Then it can surely presume that due to discrepancy of name of her father and mother, it is clear that OP has projected Faiz as her projected grandfather, and one Abul Mia is her projected father, and Kamala Bibi is her projected mother. The OP pick up the voter list of another person from another family, that is Exhibit 1, claiming them as her grandfather, father, and mother to suit her purpose, and it cannot be acted upon as trustworthy. Moreover, OP had not proved Exhibit 1 as per the Honorable High Court's order passed in WBC so and so. The certified copy of the voter list to be proved on the basis of primary evidence, that is by comparing with the electoral roll in original and on the basis of testimony of the lawful custodian of the primary evidence. Therefore, the contents of Exhibit 1, besides being unproved, also suffer from material contradictions, rendering the same to be wholly unreliable. Then, Lordship, Annexure 1, Gao Panchayat Secretary Certificate of Bandia Gao Panchayat Bhait number so and so. On perusal of the document, it is found that the authority who have issued the certificate marked as Annexure 1 have not been examined to prove the contents of the truth of the documents as required under the law of evidence. Thus, mere filing or accepting a document without proving its contents is inadmissible in evidence, and as such cannot be relied upon. Thus, OP had failed to establish the linkage with her parents. Then Paraten OP DW1 on oath deposed and admitted that Exhibit 3 is the another electoral photo ID card in the name of OP Lalbhanu Nessa, Bhait number so and so. The electoral photo ID card in her evidence in chief, where it is found that OP's own name appeared as Lalbhanu Nessa, wife of Zainal Abedin, aged about 32 years, issued by Election Commission of India on 1/10/2013. Moreover, the law is well settled that just because the name of a person enlisted in the voter list, it would not mean that she is a citizen of India. Enlistment of name in the voter list or long stay in the country per se are no proof of citizenship. On the other hand, on perusal of documentary evidence produced by OP, it is found that Exhibit 5, the family ration card, is a public document, is post 1971 document. The OP has also produced Exhibit 4, the Kabin Nama, in the name of OP Lal Bhanu, daughter of Abul Hussain, which was executed on dated 1/8/2006. Is also post 71 document. The post 71 document produced by the OP, it cannot establish her parents' existence in the Indian soil prior to 1971, as per Section 6A of the Citizenship Act 1955, and is of no help to the OP to prove her burden that she is a genuine Indian citizen. Moreover, OP had failed to produce any linkage documents that Faiz is her grandfather, Abdul Hussain is her father, and Kamala Biwa is her mother. For the reasons and discussions above, and considering the entire materials on record, the evidence of OP is not trustworthy at all and cannot be relied upon, and as such, the OP had miserably failed to discharge her burden of proof as envisaged under Section 9 of the Foreigners Act 1946, as held in Sarvananda Sonowal versus Union of India and others, reported in so and so, to prove that she is a citizen of India by birth and failed to establish that she is born and brought up a genuine Indian parents, Lordship. So, Lordship, opinion is very much clear, Lordship. And what procedure has exhibited, Lordship? 1966 voter list. Apart from this voter list, Lordship, no other voter list has been placed before the tribunal, Lordship, regarding her projected parents or grandparents, parents, as well as her own voter list has been not placed before the tribunal. Then, Lordship, although her mother, Lordship, died in the year 2018, Lordship, Kamala Bibi, procedure failed to place any voter list to prove her continuous residence within the territory of Assam, Lordship. Then, Lordship, EPIC, Lordship, already law has been settled, Lordship, regarding in Babul Islam case, Lordship. I will provide the citation, Lordship. WBC 3547 of 2016. 3547 of 2016. 3547. 14 to 23. Where it was.
2016.
Yes, Lordship. Where, Lordship, in this case, law has been settled that a PAN card or voter ID card is no proof of citizenship, Lordship. Apart from this, Lordship, these are post 71 documents, Lordship. Again, Lordship, regarding, Lordship, ration card, Lordship,
The second part was of which year?
here is not mentioned, Lordship. So, regarding that also, law has been settled, Lordship, in Taru Sheikh case, Lordship.
Second part here is not there.
I think
In
they,
petition. LCR of Assam.
I could. Yesterday, I could not able to see, Lordship, on which year it was issued, Lordship. Regarding ration card, Lordship, I want to rely on 2017 Ford GLR 295. Two 2017 Ford GLR 295. Taro Sheikh versus Union of India. Para 16, Lordship, I am relying.
What is the
Lordship, here it is said that, Lordship, Exhibit 6 is a copy of the ration card issued by the Government of Assam in Food and Civil Supplies and Consumer Affairs Department. This card is in the name of so and so, wife of so and so, that is the petitioner. There is no date of issuance of this ration card, which makes it highly suspect, and certainly ration card cannot be treated as a proof of citizenship. Therefore, the narrative which was projected by the petitioner that he is a son of so and so, is a citizen of India and born in India cannot be believed, Lordship. Yes, Lordship. Yes, Lordship. Yes, Lordship. There is nothing, Lordship, in this case, Lordship. An opinion is very much clear, Lordship.
My lord, petitioner is a, my lord, she is a mother of 5 children, my lord. Considering that aspect, my lord,
He'll be able to get Indian citizenship, becoming a mother of 5 children. Is possible under the Citizenship Act or under the Foreigners Act.
no, my lord.
In other sense, how it is possible. Exactly.
My lord, only my lord that oblige.
Oh.
May I please
lordships. For your lordship's order, my lord, I have received the report.
How it was done?
The report from additional
What is the report of the commission?
report, my lord, as per that, my lord, his land is not there, my lord. Another person name is there, my lord. Chandrakanta Kumakar versus Papan Kakati. Another, your lordship, see. In this report, my lord, I have found one Papan Kakati and Wednesday. Lordship, I have original recording. Tag number 239, Pata number 2, my. His name is not there. It's a thing for apparently.
May I submit one thing, my lord?
Okay, that's the report of the.
My lord, only I rely, my lord, pattern number 57,
Yes.
my lord.
Wow. He was good. You call him out of the
Yes, question.
Lordship.
Something else.
Regarding Lordship. No, my lord, your earlier as per your order, my lord, dag number 239, pattern number 2. That is dag number 239, pattern number 2.
My lord,
As per his version, my lord, dag number is
my lord, yesterday, 3 days ago, my lord, I have noticed the order, my lord. My lord, in the order, my lord, there is a typical mistake, my lord. My lord, patta number should be, my lord, 175. Dag number should be, my lord,
no, dag number
239, my lord.
239 হয়।
My lord, here in this case, my lord, record has come pertaining to patta number 2. But that is not our record, my lord. Record should come against patta number 157. 157, my lord.
Variant. Non correction to the itu kan keluar. Nah, 19.
19.
Mati itu mana nama tahu ini bisa. Harus 97 itu 301. Ini mana pura beli. Kalau pura kenal.
Page, my lord, 104.
Oh. Yes, same. Dark is same. Dark number 2. Only. কাগজের পর আমাকে কিনে থাকি কিন্তু কাগজ অরিজিনাল কাগজের হোক কথাটা শুনে আরো বেড়ে কিনে মাসের মাস কাগজ কিনে সেম কাগজ সেম ডাক্তার নম্বর সেম ডাক্তার করে lots of
That is now
your lordship's order, my lord. Tag number 239, pata number 2, earlier order. As per that order, we have produced that record.
come to page number 108.
What? What is it? What tomato to sauce? Yes, lordship.
There is third one.
Yes, lord.
After the word Sakra Bifaya, Rokim Porua.
Uh,
Got it? From
yes,
the top,
yes,
first,
yes, yes, lord.
second,
Sop-
and third.
Okay.
Third is Sakra Bifaya, Rokim Porua. his signature might be, right?
Yes, Lord.
Then you just read.
So-
Read this.
চক্র বিষয়ার 28/9/2018 তারিখৰ নামজাৰি নম্বৰ সোয়েনশোৰ হুকুম মৰ্মে 239 দাগৰ মাটি উত্তৰাধিকাৰী সূত্ৰে মহিজুদ্দিন জহিমুদ্দিনৰ পিতৃ
নইমুদ্দিনৰ স্থলত
ফলত জহিমুদ্দিন
জছিমুদ্দিন
জছিম
পিতা নইমুদ্দিন
yes,
আৰু কাছিমুদ্দিন
পিতা
পিতৃ
নইমুদ্দিন
আৰু ৰমেলা
ৰমেলা
পিতৃ নইমুদ্দিন
আৰু
আৰু নজুমুদ্দিন পিতা নইমুদ্দিন জমিৰ আলী পিতা নইমুদ্দিন আৰু কুমৰুদ্দিন পিতৃ নইমুদ্দিন আৰু জয়গুণ নেছা
নেছা
পতি
প্ৰতি
নইমুদ্দিন নামত
নামজাৰি কৰা হ'ল।
হ'ল। Okay, so
Yes,
decision there has to be an order of circumstances of 28th of December 2018 to this particular file,
fine.
right?
Yes, Lord.
Now come to page number 107.
Or which one? 107.
106.
Lord. 106.
Or you can come to 106, the top,
Top. Oh,
there are three ducts. 212, 239, and 269.
yes.
In duct number 239,
Dagor.
this particular patta,
Oh,
Patta number 157, my lord.
patta number is 157.
yes, Lord.
239 consists of 1 biga, 15 lectures,
Yes, Lord.
right?
Yes.
15 is there. So 1 biga, 15 lectures.
Yes.
Now you'll get the Noimuddin at serial number 7 on left.
Serial number. Left. Yes, 1, 2, 3, 4, 5,
Then
6,
again you'll
7.
get Noimuddin at serial number 9.
Yes, no, it didn't. Pita.
You'll get 7 and 9.
Yes, Lord. 7, my Lord. 9. Ask less,
You
sir.
read the order again that relates to only with the land of that number 239.
Yes.
Now please come to the right hand column. The last note,
Your 6. Serial number 24.
jha,
Yes, Lord.
after Borgojo, jha.
Jha.
The last column on page number 106.
Yes, it is our number 97.
This is not repeat, this is not, this is something repeat door number.
Yes, Lord.
The first number.
The first number.
Repeat দরখাস্ত নম্বর 21 by 96/97 ইংৰাজী তাৰিখৰ হুকুম মতে
হুকুম মতে
212, 239 আৰু 269 নম্বৰ ডাগৰ
নামজারি হিসাবে
উলম নামজাৰি হিচাপে 3 নম্বৰ পাট্টাদাৰ নইমুদ্দিনৰ নাম ৰদ কৰি চামেলা খাতুন আৰু কবিৰন নেছাৰ নামত up to page number 107 বাহাল ৰখা হ'ল।
রাহুল. Yes, Lord.
So the name of Noimuddin from this particular duct that also includes duct number 239
Yes, Lord.
was deleted. If the name of Noimuddin was deleted
Lord.
long back in the year 96-97
Yes, Lord.
from duct number 239, how can these legal heirs name can be incorporated in the land record?
Thereafter, your lordship kindly see.
by an order of 28th of September 2018, which you have read past at 108.
Your Lordship.
If you read the
Socrovifera, 28/9/2023. 13,
page number 107, again,
Lordship.
you read Neo on the right, the first column
Lordship.
on the right hand side.
চিঠাত দিয়া
চক্ৰবিকাৰ 6/6/2009 ইংৰাজী তাৰিখৰ হুকুম মতে খৰিদা দখল সূত্ৰে
is not.
পাট্টাদাৰ
Sovereign Nessa.
ছবিৰুন নেছা
Follow up.
স্থলত 212 নম্বৰ দাগে 2 কথা 2 লেখা
Yes. 239 লাগে।
239 নম্বৰ দাগে 1 কথা উত্তৰ লেখা
লেখা।
4 কথা জমিত তাতে নাম হয়।
Very well.
The Noimuddin's name was deleted long back, the year 95, 96, 97,
Yes, Lord.
from all the 3 tasks,
Yes.
right?
Right.
How can there be another order in the year 2018? These particular land records placed before the court by the petitioner clearly reflect that after such deletion of the name of his father in the year 96, 97, from those 3 tasks, particularly that also includes the tag number 239.
239.
There is no other column, no other remarks in any other way to show that his name was incorporated afresh.
No, yes, Lord.
That is why we wanted to know how come this circle officer again in 2018 could have incorporated the name of the legal heirs of Sheikh Noimuddin. First of all these documents are after 1971.
Yes, Lord.
All are after 1971.
Good.
The document he has placed before the court because of the reason that to show that he is the son of Noimuddin. But where is the remark? Which remark shows that Noimuddin's name was afresh considered for those 3 tag
No,
numbers?
no. তুমি কোৱা, তুমি থাকি যাবা। তুমি কোৱা।
My lord,
Yes, Mr. Manaf.
yeah, my lord, yeah,
Which
lordship,
particular remark
Yes.
can you show us?
my lord, yes, my lord. Your lordship kindly see letter on 2013,
Page number
page number 107.
107. Yeah.
107, order dated, my lord, 8/3/2013. চিঠাৰ চক্ৰ বিষয়াৰ 8/3/2013 ইংৰাজী তাৰিখৰ হুকুম মতে খৰিদা দখল সূত্ৰে পাট্টাদাৰ ৰেহেনা ৰমেশ জহৰুদ্দিন নিলছানৰ স্থলত 239 নম্বৰ দাগৰ 2 কথা 8 লেচা জমিত নইমুদ্দিনৰ পিতা নয়ান্দিৰ নামে নামজাৰি কৰা হ'ল। Later on, my lord. Later on. Thereafter, your lordship kindly see another order. চিঠাৰ চক্ৰ বিষয়াৰ হুকুম মতে মহোদয়ৰ 7/5/2013 ইংৰাজী তাৰিখৰ হুকুম মতে খৰিদা দখল সূত্ৰে পাট্টাদাৰ গণৰ স্থলত 112 নম্বৰ দাগৰ 1 বিঘা 1 কটা 6 লেচা জমিত
We are not
মোহাম্মদ
concerned with that. We are not concerned. We are concerned only to 239.
Yes, my lord. Yes, my lord. That is my lord, right, my lord. My lord, since my lord, later on I have purchased some land under the patta number 157, dag number 239. That's why our names have been incorporated, my lord. And my lord, record shows, my lord, regarding patta number 2, that is not my lord, correct. Patta number, my lord, 2-3 days ago, my lord, I have noticed your lordship order. There is some typical mistake. In place of patta number 157, patta number 2 has been inserted, my lord. That's why, my lord, wrong record has come, as per my information, my lord. My lord, in fact, my lord, there is some land, my lord, in this dark.
Just the
Your lordship kindly see, my lord.
will be correct.
My lord, may I forward this part, my lord, is a clear part, my lord.
They mentioned that there are no case record available. Case record available.
ভুল লিখিছে, ভুল আহিছে 2000 নম্বৰ বেলেগ তাত থাকিব পাৰে, তেন্তে থাকিব পাৰে। তাত বেলেগ তাত থাকিব পাৰে।
My lord, one letter, circular official letter also clearly mentioned, my lord. 22/3/2024 letter.
My lord, I am sorry to mention, my lord. My lord, you lordship kindly see, my lord, order dated 23/2/2014, 2024, my lord. My lord, there is some, my lord, typical mistake, my lord. I have already pointed out, my lord. My lord, that's why, my lord, this record has come, my lord.
Clarify.
My lord, my lord.
Come to page number 39.
Okay. 39, my lord.
Yeah.
Read the name of person.
My lord,
What is the name of the person?
my lord, present petitioner, my lord, Kosimuddin, my lord.
What is the name of the person written there?
My lord, herein is a Kasimuddin, Kasim Ali,
Father's name,
father's name, Noimuddin, late Noimuddin.
marital status,
Here is, my lord, unmarried, my lord. My lord, this is the, my lord, reference, my lord.
come to page number 41.
My lord.
What is the date?
Date, my lord, 29/5/2001, my lord.
29/5/2001.
My lord.
Now come to page number 107.
107.
Read that portion which I have again highlighted. Video.
Page 107, my lord.
Need for it. Here for
my lord.
Read that for.
পড়িব দিছে
I like it. So, তিথাৰ চক্ৰবিষয়া মহোদয়ৰ 8-3-2013 ইংৰাজী তাৰিখৰ হুকুম মতে ফৰিদা দখল সূত্ৰে ৰেহেনা ৰমিজ জহুৰুদ্দিন নিলছানৰ স্থলত নইমুদ্দিন পিতা নয়ান্দিৰ নামে নামজাৰি কৰা হ'ল।
That was sometimes in 2013.
13 May.
And while this matter was recorded in here in May 2001, your father
2001, my lord.
was not there. Just please tell us, Sir Manaf Pandit,
My lord,
your father passes that.
that is my lord, report, a reference, my
This
lord,
is the reason we're asking you
my lord.
to give us this.
What's it? That
You're clearing.
we have one letter also issued by the, there is no
My lord, on the
no-
other hand, my lord,
no case record.
on the other hand, my lord, that particular reference, my lord, also under challenge, my lord. That reference is not, my lord, correct, my lord. At that time, my lord, Noimuddin was alive, my lord. I was unmarried. And Noimuddin died, my lord, 2000, my lord, 17, my lord. Reference also under challenge, my lord.
What's this one letter is there, my lord. In this letter, it is mentioned by the circle officer that to the additional deputy commissioner with reference I have the honor to hear with case of Miss case so and so, original connection number so and so.
The circle officer,
There is no case record.
the
Wrong order.
deputy commissioner numbering.
Case number to বেলেগ
Case number to TPS.
case number to যদি বলো case number to যদি বেলেগ
Pata number will accept.
Shall list the relevant record.
the circle officer has given
Original.
already the mutation case is not available in the office.
That's
That is not available. One letter issued by the circle officer.
Case number to submit. Case number. Case
107
number.
Case number.
Case number 61. Case number
Case record number
96.
circle officer.
One. 97.
Land pertaining to tag number 239. Of pata number 157. Of village number 3, Lark layer 2. Lot number 2. Of Possum Forfeiture. Under Forfeiture Revenue Circle. Subdivision Nalbari district. Wherein the circle officer or Forfeiture Revenue Circle by his order it is 08/03/2013 incorporated the name of Naimuddin, son of Noyanandi, by right of purchase in possession substituting the name of Rehena, Rumiz, Zoharuddin, and Nielsen pertaining to 2 quarters, 8 acres of land opposite Dock number 23. As expected, the Jamabandi opposite number 2 lot. Page number. On the page. Copy of the certificate. Thirty-eight. This record you may return.
Obliged, my lord.
I can move my lord, the lord will next kindly grant another 2 weeks time to file an affidavit in this case, my lord. Extension of time for registration, my lord.
What is your instruction?
It is placed, my lord. No decision has yet been taken, my lord. It is placed by them, my lord.
Please.
My lord, no, another 2 weeks time, my lord, for filing affidavit. I have not get written that, my lord, instruction date yet, but they have placed the matter, my lord. It is under discussion. So if a decision has been taken, my lord,
Sir, fine.
yes,
Failure on the part of the respondent authorities to place the relevant instruction in the matter, the court shall consider to dispose of the petitioner in excess of listing of the matter. Matter is pending for your instruction since 19th of January 2018. Not that far, right?
yes, only, my lord, 2 weeks time, my lord, I will get it.
Why further 2 weeks time, Mr. Pai? You will give so much time to the public. You give. They are much more powerful than the public. That is the reason. Time. You will seek time, but it will not come again next week. After 2 weeks, there will be a vacation.
Next week, your lordship, I'll get it. By 10 days, my lord. Before vacation,
Deposit cost. Legal service. Certain cost. Concept. There cannot be one-sided with, right? Friday.
Yes. This Friday one.
Feel if your
Lordship,
Mr.
my-
Majumdar is having some instruction, let us pick it after some. This number, you have to compute it. Mr. Sharma, wanted you read that opinion. Get your view. What is your view? Therefore, you have to accept and real on the record. And it also is not sure. I might. It was not the opinion, it was. Yes. Yes. Not it. Very, you know, considering only matter is more than 7 years. It is always stay order. Document connect for not available. That we are not that we yes, prosecute have totally but yes. But,
Malad, item number 5 and 6, Malad, I praying for adjournment, Malad.
why?
Malad, last time I kindly fix the matter on after vacation any day, Malad, 18, Malad.
So
I am-
this is the matter of 2007.
Yes,
You
madam.
have obtained stay.
Malad,
That matter is pending.
so far, Malad, the item number 5, I could not able to contact my client, Malad.
Not
And
required.
Malad,
you
item
need
number 6, Malad, as per my instruction, they have Malad choose another advocate, Malad. So I have to confirm. Malad, little accommodation, Malad, kindly.
They
On
have
it.
to move.
Yes,
Thursday.
Malad.
Indeed. Please prepare.
Obliged.
So he seeks a case, some other council have been acting.
Please hold on, my lord.
Yes, will you appear, Mr. Marang or Mr. Das, take your seat.
Oh, okay.
Yes,
Page 13, my lord, para 7. On careful scrutiny of the above, it transpires that the case number so and so, that is mentioned earlier one, OP was Saleha Begum, aged about 22 years, wife of Sanur Ali, village Sariatuli and country of origin was not disclosed in form number 1. I am therefore of the view that the case number so and so, that is 4590 of 2006, is not exactly related with the OP of the instant case, and the principle of res judicata does not apply. Do the name of Kasem Ali is mentioned in 1965 voter list? That is. So res judicata My lord, identity of the person, whether it is she is the same person or not, that is not properly proved, my lord. For the reading of the, my lord, earlier opinion, it is not a reason order, my lord, because page 11, my lord, the discussion at para number 3, my lord, 4, my lord. In fact. The exhibit 1 is the photocopy of the voter list of 1965 of number 47 Sorbuk Legislative Assembly constituency, which is proved in original. We have no objection on that, my lord. In exhibit 1, the name of Kasem Ali is enlisted, by serial number so-and-so, house number so-and-so, part numbers during the 16. During argument, learned advocate for the OP had submitted the certified copy of the voter list of 2011 of 59 Nalbari constituency, Nalbari Legislative Assembly constituency. From the certified copy of the voter list, it is seen that the name of the OP is enlisted by serial number so-and-so and marked as D. Police in form number so-and-so, reference mentioned in OP's father as led Kasem Ali. As the name of OP's father is enlisted in the voter list of 1965. So OP's father Kasem Ali is a citizen of India, and being the daughter of OP, Muhammad Saleha Begum alias Khatun is also a citizen of India. So it has no reasoning, my lord. Mere enlistment of the petitioner's name in the voter list of 2005, 2011 cannot be ground up, my lord, and it is not given, no reason is given, my lord, simply saying that her name is appearing in the voter list of 2011. This is not a reason order. Furthermore, my lord, the respondent petition, the tribunal has clearly said, my lord, at para 7, it is considered in the new opinion, my lord, at para 7, it is considered that the careful scrutiny of FT case number 4593 of 2006. That is the earlier case, my lord. It's not related to the petitioner, and that fact has to be proved, my lord. This the parties are the same. That means he is the same person. First of all, two things, my lord. There, the tribunal the petitioner has to prove for considering the res judicata. First of all, the parties must be same, my lord. Secondly, the cause of action must be same. Thirdly, my lord, that the order which was passed earlier is a reason order. So the petitioner failed to establish there before the tribunal, first of all, my lord, that they are the same party, because he has simply filed a petition saying that I'm the same person. Against my name, my lord, against the petitioner's name, there was a case where she was declared Indian. So she being Indian, declared as Indian, the second notice was this my lord case may not be instituted against her. That is her only claim. That has not been substantiated with any proof or any evidence. Secondly, my lord, the opinion dated 8/9/2014, who is the petitioner is my lord taking the benefit. That is not a reason. So both this condition has to be fulfilled to be considered under the the res judicata. You know, and in merit, my lord, the petitioner,
Not on that.
yes. So by my humble submission is, my lord, first of all, the petitioner could not establish that she is exactly the same person who's against whom earlier, my lord, the proceeding was drawn. Secondly, the first opinion, even though that, my lord, the earlier opinion is not a reasoned opinion, so it may not be it will not come under res judicata, my lord. The issue of reasoned order has been settled by this number court in FT case, my lord. It is in WPC number 251 of 2023, my lord. 251 of 2023, my lord. Rafiqul Islam versus Union of India. And another case, my lord, here in para number, my lord, 6, it is clearly said. May I read that portion, my lord? Principles of res judicata under the law requires two conditions precedent to be satisfied. The earlier dispute must be between the same parties. That is what I have mentioned, my lord. Secondly, the issue between the parties must be decided. The very condition of the issue that the issue must be decided requires that it must be decided by a reason order and not by an order merely depicting the view that the foreigners tribunal may have taken without any reason. From such point of view, we are unable to accept the plea of petitioner that the subsequent proceeding against the petitioner number so-and-so corresponding to so-and-so is barred by principle of res judicata. So if it is not by reasoned order, so the res judicata will not apply and it is not barred by res judicata, the second proceeding. So here is the case, my lord, there is no reason given in the first opinion. So it is not barred by res judicata. The second opinion has to be considered in, my lord, different. No, my lord. Yes.
We have flag mark 1 and flag mark 2, that go to it. Read the first paragraph.
Received the reference on transferred from the erstwhile IMDT Nalbari by letter number so and so and registered FD is produced the reference in prime city. It appears that Hopi Muhammad Saleha Begum is a foreign national and issue press notice on OP fixing so and so for service report and return statement.
So here it appears that there was something by police. The
IMDT.
case number was sometime of 2006.
Yes. 2006. Yes.
Now read the page mark 2. This was the first inquiry in 2009.
Yes.
This is the case number 128 2009. Then it was then sometime.
This is a new case, 2009.
No relevance with the first paragraph. Yeah, this case that you are holding the record relates to a case where it was earlier under the IMCT. Hereafter it has been converted to unreported tribe.
Yes, ma'am.
But here is a separate, there's a fresh proceeding under 2009.
This is under foreigner sect.
That is why I asked for the first paragraph of this particular reference. It doesn't tell you.
Then my lord, in that case, my lord, there will be two cases, my lord. First of all, because the Sabananda Sunwala has clearly said.
They are not on that. You can understand whatever, but the tribe, their members have been changed.
Yes.
There are 3 members came in between. So what we found that there should have been a separate record.
Oh, yes. Both cases. I think
Do the records of both the cases were called for until we have received the record of this.
yes.
There is no other.
Let's check, my lord, probably. Let me check. It is under FD3 2009 and FD case number
128.
109.
No, as per the report of the note of the tribunal, the matter was transferred to this tribunal. after
Tribunal.
The IMDT Act was deleted
Yes.
or struck down. Right? But this is not the case there.
We have, my lord, we have not called for the second report, my lord. Second report. Probably
called
this is-
for.
Yes.
By order, it was called for.
Opinion. Kita case number saya, opinion number 3, FP reference number 128. SP reference 150. Bad letter number change the reference to 206. Letter number 206. Probably the
While issuing notice, hard Mr. Bikita. The file. People. While issuing notice to the respondent on 03/05/2017. Court also call for the records of FT within bracket NAL, all capital. Bracket close, case number. Capital N, bracket close. 4593/06. Arising out of SP reference number 591/2000. That was disposed of by the tribunal, but it was disposed of by the foreigners tribunal already. One. Hold on, please. On 08/09/2014. Along with the records of FT within bracket NAL, case number within bracket N, bracket 3/09. Though the records of FT within bracket NAL, case number within bracket N, 3/09.
My lord, may I clarify this, man? May I clarify? My lord, what is this first para? My lord, can he receive the reference on transfer from R12 IMDT Nalbari White letter number so and so. This is a common letter, my lord, issued by the government of Assam for transferring all the matters. This is not IMDT reference. This is not an IMDT reference. But then, my lord, in prima facie, it is OP. Then this, my lord, reference 120.
That's true.
Yes, that's.
Though the registry received the records of FT within bracket NAL of case number in bracket capital N of and bracket close 3/09 from the foreigners tribunal number 1 Nalbari. That was disposed of on 30/03/2017. But FT Nalbari case number N of 09. arising out of SP reference number 128. But the record of FT in bracket and case number 4593/2006. Date with C. Registry shall issue reminder to the foreigner tribunal notary for the records of FT in bracket NAL case number in bracket N bracket close 4590/2006. Arising out of SP reference number 591/2000. Disposed of on 0809 by the foreigner tribunal. This order before. The Superintendent of Police order Nalbari also be informed in that regard. A copy of this order be furnished to Mr. Dave Extending Counsel from Department. For his necessary or community to the foreigners tribunal body as well as Superintendent of Police. Please come. 7th of May. Pass on the record, Mr. President. Yes. We'll have it on 7th of May along with the other record.
Next, Lordship.
Yes.
Lordship, writ petition was dismissed on the ground that page number directly, Lordship may kindly go for page number 22 in last part. Page 22 of review.
Yes.
Lordship, last paragraph. Here on analysis of the evidence in record, we find that petitioner failed to prove that Abdul Jalil is the son of projected grandparents who migrated from Bangalpara to village near Kaurbaha 40 years back. Contents of Exhibit A certificate issued by Gambura DW2 itself doubtful in as much as the state Gambura failed to support the fact that grandparents of the petitioner migrated to the said village 40 years back. Coupled with the evidence of DW3, which is contradicted by the father of the petitioner herself, stating that he casted his vote since the year 1997. There is no link established between the grandparents and the father of the petitioner, there being no voter list showing the name of the father of the petitioner with the grandparents. This is for the main ground for rejection or declaring for there is no link. Lordship, to substantiate it, I have my Lordship, I want to draw attention of your Lordship at page number 34 and 32, first 32 and next 30. here is the voter list of 1966.
Hmm.
Showing the name of the voter is Toleb Ali. Toleb Ali is the grandfather of the petitioner. Next, your lordship, page number 34. Here is the voter list of 1970. Here is also Toleb Ali, grandfather of the petitioner. Then, lordship, Annexure F, page number 36. The voter list, Abdul Jalil. Here the father of the petitioner, showing in the year of 1997. Now the question relates that whether Toleb Ali is the father of the Abdul Jalil. That's it. To substantiate this lordship, I would like to draw your attention in the voter list of 1993, page 40, and sorry, page 40. Here is another voter list in the year of 1993. Page 40. Is another voter list of 1993.
Yes.
And more than lordship, kindly draw one another annexure. Annexure K, page 48 is a land document. Here, name of the patadar and father's name. Column number 2. Abdul Jalil, father Taleb Ali. So here the Abdul Jalil, father Taleb Ali. Abdul Ali is the son of Taleb Ali. To prove this fact, here the document I have enclosed, which my review petition. Lordship, to substantiate where the petitioner is the daughter of Abdul Jalil, we have enclosed one school certificate, Annexure J, page 47. One school certificate. Kulsum Begum, daughter of Abdul Jalil. The next question as to why Taleb Ali casted the vote at Bangalpara and Abdul Jalil has been casting his vote at Kaur. The Taleb Ali who casted the vote in Bangalpara is the father, resided at Bangalpara, and Abdul Jalil who casted in Kaur is the same person, belongs to same family. To substantiate the fact, we are filing one additional affidavit supporting with 2 Kaur certificates. Page number 59.
Please take your seat. he will come back at Yes, Mr. Pine. What the review petitioner wants to say that in the judgment at page 22, later part, the court observed that there was no link established between the grandfather of the proceeding and the father of the proceeding.
Yes, that is true.
There being no voter list showing the name of father of the petitioner with the grandparents. Now, here, the proceeding has annexed two documents to show, in fact, he wants to say three documents. One is the voter list of 1993 at page 41, where the name of the proceedings projected father shown with his grandfather. Not professor, but proceedings father has been
Abdul Ali.
shown. Page 41.
Abdul Ali. Madam.
Abdul. Then also the land purchased by the father of the proceeding. Damabandi at page 59. But what we found is, what is the linked document that has been placed? One document now the proceeding have placed, that is the transfer certificate from the school obtained on 28th of November 2018. And were true that she left the school on 31st of December 2002. Do you have the copy of the writ petition?
No one.
The petitioner hasn't annexed the written statement,
Yes, it is not annexed, my lord.
accepting the evidence that she has annexed. For the This is the written statement. Can you read it? It's not very long.
Yes. Written statement of second party, madam. Madam, the above one second party named second party most respectfully back to state that the second party is a citizen of India by birth and presently residing at village Bangalpara, Moja Ramdia, PS Pujai, district Kamrup, Assam. The second party marriage was solemnized with Nazrul Islam, son of Abdul Sattar, resident of village Bangalpara, that is aforesaid address. Prior to her marriage, the second party was living in the village Nis Kaurbaha, post office Barghuli, Moja Kaurbaha, district Baksa, BTD, Assam, in where second party was born. Then, para 2, my lord, the allegation made against the second party is totally fact, baseless, fabricated only to harm the second party. The second party did not enter in Assam after 25/3/1970 was as alleged by the SP Kamrup, Assam. Then the second party is casting vote since 2005. The second party, the party's name is existing in the voter list of 2005 by house number so-and-so, serial number so-and-so, patta number so-and-so, village Bangalpara, Moja so-and-so, so-and-so. That is then the second party has got voter ID card. She is an Indian citizen by number so-and-so, so-and-so. Then the second party's father is Abdul Jalil and mother's name is Jaleka Khatun. Her grandfather's name is Let Taleb Ali and grandmother's name is Let Joygun Bibi. The second party's father name is existing in the voter list of 1997 by so-and-so, village so-and-so, and so and so, so and so. The second part is grandfather's late Taleb Ali, son of Hussein, and grandmother late Joygun Bibi, wife of Taleb Ali, is Taleb Ali's name exists in the voter list of 1966, White House number so and so, in the village Bangalpara, Mauza Ramdia, Haju, under PS Haju, district Kamrup, Assam. Then the second part is grandfather and grandmother names are existing in the voter list of 1970, White House number so and so, at Bangalpara village, Mauza so and so, Haju. Then the second part is grandfather shifted his home from Bangalpara to village Nis Kaurbaha, Mauza Kaurbaha, district Baksa, Assam, after the year 1970, and in the village Nis Kaurbaha, the second party was born. The second party's grandfather and the family, along with her father, when he was minor, went to live in the village Bangalpara, Mauza Ramdia, PS Hajo, district Kamrup, Assam. That in the above noted circumstance, it is very clear that the second party is a citizen of India by birth, and the allegation is made against the second party by the state of Assam is to be dismissed. This is the case, and he exhibits A, certificate of Gambura, B, certificate copy of the voter list of 2005, voter ID, certified copy of the voter list of 1997, voter list of 1966, voter list of 1977, 70, and the affidavit. So that is the WS, my lord.
Read that para again, the para 5 or something where his father, while he was minor, have shifted.
Yes.
Read that.
That the second part is grandfather shifted his home from Bangalpara to village Nis Kaurbaha, Mauza Kaurbaha, PS Thankapur, district Baksa, Assam, after the year 1970. And in the village Nis Kaurbaha, the second party was born. The second party's grandfather and his family, along with his father, when he was minor,
When his father was minor,
when his father,
so
he was minor, went to live in the village Bangalpara, Mauza Ramdia, yes, that is.
Okay.
Now this is the WS, my lord.
this is the WS. Here there is no mention that his father had purchased land.
Any proper plan, his
There
father
is-
has any
Here in the
proper plan.
categorically, the procedure is stated that his father had cast vote in the year 1997.
Yes, only 97, does
There
not
is no
mention about
mention-
93,
There is
totally anything. Then, my lord, he has not stated that he has read in any school. The petitioner has stated
Did
any,
not mention it.
there is no mentioning of it. Now, in fact, my lord, in the grounds of review also, these things are not there. They have not asking for review for this ground.
No, the reason for it that the court, the judgment passed earlier, observe that there is no link to establish
Yes,
between the grandparents and the father.
that is the fact, my lord. There is
Now, the petitioner has annexed another voter list of 1990.
yes. 93, my lord, this has make no relevance because 93 and 97 voter list is same voter.
No. Just see what we want to tell you. This is here because the he has annexed two particular documents. One is the voter list, other is the land document.
Yes,
Now, page number 41. As per this, the petitioner, his father was 45 years in the 1990.
yes,
In that case, birth year of the petitioner's father would have been 1948.
Yes.
And if you add 21 years, he was eligible to vote in the year
1969. 19.
So he was not a minor at that.
Yes, he was not a minor.
Secondly, the 97 voter list, what was his age? He was 40. In the voter list of 1997, he was shown as the 40. It's available in your review petition.
The review petition is available.
37.
Yes. He was 40 years in 1997, as per this document.
Then also he was eligible to vote in the year 1978.
Yes.
But there is no mention in the written statement as to when her grandparents expired.
Nothing is there, my lord.
So there is no voter list to show that reflecting the name of the father of the
Petitioner.
proceeding, along with his or her, sorry, her grandparents,
Okay.
either from 1969 or from 1970.
78, 77.
Now, there is no document to show that, or nothing to prove that Talewali of village Bangalpara under Hajo police station of Moza Ramdia existed at village Kaurbaha, Niz Kaurbaha. Because after 70, there is no voter list
Yes.
of grandparents of the proceeding.
After 70, there is no. The link between the petitioner and the grandparent is the necessary here.
And not true.
Yes, that is not.
There is also no link between, no linkage to prove between the proceedee and the proceedee's father.
Father.
Because there is petitioner did not mention in her written statement that this is studied in his school or note.
Yes.
Gaombura has adduced evidence. It is available in the
Yes.
writ petition.
It's 70 years, my lord.
In the writ petition, you will see
Yes, it is there. May I read the, my lord, cross part of page 55.
yes.
গাঁওবুঢ়া গভৰ্ণমেণ্ট গাঁওবুঢ়াই এজেড এবাউট 70 years মই আজি আদালতত প্ৰচিডি কুসুম বেগমৰ সাক্ষী দিব আহিছোঁ মই প্ৰচিডিক 20 বছৰমান আগৰ পৰা চিনি পাওঁ প্ৰচিডিৰ ঘৰ নিজ উঙৰবাহা গাঁৱত
Niz Kaurbaha.
উঙৰবাহা গাঁৱত বাক্সা জিলা প্ৰচিডিৰ বিয়া বঙালপাৰা গাঁৱত হোৱা বুলি মই জানো হাজো থানাৰ অন্তৰ্গত প্ৰচিডি দেউতাকৰ নাম আব্দুল জলিল আৰু মাকৰ নাম জলেহা খাতুন আব্দুল জলিৰ ল'ৰা ছোৱালী কেইজন মই নাজানো প্ৰচিডিৰ গ্ৰেণ্ডফাদাৰৰ নাম তালেক আলী মই প্ৰচিডিৰ গ্ৰেণ্ডফাদাৰক জীৱিত অৱস্থাত পোৱা নাই প্ৰচিডিৰ বাপেকে ভোট দিয়ে কিন্তু কোন চনৰ পৰা দিয়ে মই নাজানো প্ৰচিডি বিয়া হোৱা অনুমানিক 12-15 বছৰমান হৈছে বিয়া হোৱা অনুমানিক 12-15 বছৰমান হৈছে। অনুমানিক প্ৰচিডিৰ বাপেকৰ মাটি মোৰ লাটত আছে। প্ৰচিডিৰ বয়স আনুমানিক 30 বছৰমান হ'ব। প্ৰচিডিৰ বাপেকৰ নামত বিদেশী বুলি কেছ থকা মই নাজানো। মই প্ৰচিডিৰ বাপেকৰ কেইজন ভাই ককাই আছে নাজানো। প্ৰচিডিৰ মাক দেউতাক বৰ্তমান জীৱিত আছে। মই আদালতত গাঁওবুঢ়া দিয়া চাৰ্টিফিকেটখন এক্সিবিট A হিচাপে দাখিল কৰোঁ।
So if you read this particular paragraph
Yes.
and our written statement, where they clearly stated that our grandparents, while her father was
Minor.
after 1970, shifted to village News Karwa.
Nis Kumarbaha.
News Karwa. This man is of 70 years old.
Yes, ma'am.
He is the Nampura of News Karwa.
Yes. He has not
So-
seen.
He was born sometimes in 1946.
Yes. He should know everything, ma'am.
In the 1970, he was 14 years old.
Yes.
From the same village.
He should have seen the grandfather.
Definitely, he should have seen
Yes.
her grandparents. And also should have been aware
About the brothers and sisters.
24, not 14 years, 24 years. So 24 years is,
Young enough.
so he doesn't know the grandparents, he doesn't know the brothers
The
of
brother and sisters of the
Uncles
father of the
uncles
petitioner.
and aunts of the prosecutor.
Yes.
Now, another witness was there. He is Muzammil Ali, you'll get it at page 62.
Yes. Mujammil Ali.
Hmm.
So the co-villagers, my lord.
Yeah.
Is it
Great
about
big
7?
rock.
Is it about 76 years?
Hmm.
মই প্ৰচিডিক 25 বছৰ আগৰ পৰা চিনি পাওঁ। So if he's 76 years, প্ৰচিডি should be known to her, known to him, my lord. এতিয়া প্ৰচিডি বঙালপাৰা গাঁৱত
Hajo Thana অন্তৰ্গত।
yes, গাঁৱত হাজো
বাস
থানা
কৰে।
অন্তৰ্গতত বাস কৰে। প্ৰচিডিৰ ভায়েক 2জন আৰু ভনীয়েক 5জনী। প্ৰচিডিৰ খুৰাক 4জন আৰু তাৰে এজন ঢুকায়। তেওঁলোক ক্ৰমে কলিমুদ্দিন, উছমান আলী, প্ৰচিডিৰ বাপেক। তেওঁলোকে নিজ গাঁৱত ভোটদান কৰে। প্ৰচিডিৰ বাপেক 1977 চনত পৰা ভোটদান কৰে আৰু এতিয়াও ভোটদান কৰি আছে। মই 1965 চনৰ পৰা ভোটদান কৰি আছো। প্ৰচিডিৰ বাপেকে ৰমজান নামৰ লোক এজনৰ পৰা মাটি নিজ গাঁৱত কিনিছিল, কিন্তু কেতিয়া কিনিছিল মই নাজানো। বৰ্তমান প্ৰচিডিৰ পৰিয়ালৰ কোনো লোক জীৱিত আছে মই নাজানো। কোন লোক জীৱিত আছে মই নাজানো। আব্দুল জলিৰ প্ৰচিডিৰ ফাদাৰ জোৱাইক হৰিম আলী মোৰ ঘৰত প্ৰায় 5 বছৰ
আব্দুল জলিৰ proceedings father জোৱাইকে
হৰিম আলী মোৰ ঘৰত প্ৰায় 5 বছৰ
জোৱাইক হৈছে হৰিম আলী।
yes madam জোৱাইক হৈছে হৰিম আলী মোৰ ঘৰত প্ৰায় 5 বছৰ কাম কৰিছিল। তেওঁ 1974 চনৰ পৰা 1981 চনলৈ আৰু তেওঁৰ অনুৰোধ মৰ্মে মই আজি আদালতত সাক্ষী দিব আহিম।
The request of
On the request of the my lord,
that son-in-law,
husband of the
son-in-law of the
yes
proceedings
son-in-law of
father.
the proceedings father,
That is the brother-in-law of the.
petitioner.
Now you come to page number
60 my lord.
page number 69.
Yes, this is Abdul Jalil, the projected father my lord. Abdul Jalil, late Taleb Ali, twenty-fifth of April 2016. Prosidi Kusum Begum, মোৰ তৃতীয় ছোৱালী, মোৰ পৰিবাৰৰ নাম জলেখা খাতুন, মোৰ ল'ৰা 2জন আৰু প্ৰচিডিৰ সৈতে 6জনী ছোৱালী। ল'ৰা 2জন ক্ৰমে আইনুল হক, জামাল হক। তেওঁলোকে এইবাৰ LAC ইলেকশ্যনত ভোটদান কৰে। মই 1997 চনৰ পৰা বাক্সা জিলাত ভোটদান কৰোঁ। মই 1997 চনৰ আগত কাৱৰবাহা গাঁৱত ভোট দিওঁ যদিও মোৰ ভোটাৰ কাগজ নাই। মোৰ নিজৰ ভাই ভনী নাই, কিন্তু মোৰ সতীয়া ভাই ভনী
সন্ধিয়া ভাই তিনিজন,
সতীয়া ভাই ভনী
ভনী নহয়,
অ,
সন্ধিয়া
ভাই
ভাই তিনিজন।
তিনিজন। তেওঁলোক ক্ৰমে কলিমুদ্দিন হুছেমান জীৱিত আছে আৰু ৰমজান আলী ঢুকাইছে। মই বঙালপাৰা 1970 চনৰ প্ৰায় 2-3 বছৰ পাছতে কাৱৰবাহা গাঁৱলৈ বাক্সা জিলালৈ স্থানান্তৰ কৰোঁ। মই কাৱৰবাহা গাঁৱত মাটি কিনো। মই উক্ত মাটি বিৰু কলিতাৰ পৰা 8-10 বছৰ আগত কিনো। মই অহা তাৰিখত মাটি কিনা চেলডিডখন আদালতত দাখিল কৰিব পাৰিম। উখেতালিৰ মাটিত মই বসবাস কৰিছিলোঁ, কিন্তু এতিয়া নিজে মাটি কিনি তাত বসবাস কৰোঁ। আমাৰ পৰিয়ালৰ কাৰো ওপৰত বিদেশী বুলি কোনো কেছ চলা নাই।
Here, three things you have said.
Yes, ma'am.
Here, the father of the proceeding himself stated that only from 1997 he had
He's
cast
casting
vote
vote,
at
Bangalpara,
no
Kaurbaha.
Nils Kaurba,
Yes, correct.
and prior to that he had cast vote at Bangalpur.
Yes, there is, but he has no voter list.
Then he said that he doesn't have any brothers of his own.
Yes, ma'am. That is the person who is the other, the
Right.
evidences.
He doesn't have any brothers of his own, and have stepbrothers.
Step brothers. That
And the
stepbrother
stepbrothers-
issue is nowhere discussed, nowhere disclosed.
And
That
then
he has a
out of
stepbrother.
the 3 stepbrothers, one has expired.
Yes, ma'am.
But the other witness said that there are 4 brothers.
Yes.
Now coming back to voter list of 1966.
Six Taliban
Taleb.
at Bangalpara village. 66 and 70 is Taleb Ali. Both these are in Bangalpara village.
1970 voter list at page 32 reflects along the other brothers of Taleb.
Yes.
So when the petitioner himself, the proceedings father himself said he did not vote. Now this voter list of 1993, how it will have any effect?
Well, first of all, my submission will be this is a review petition. He has to show that there is an error apparent in the face of the record.
Let us see.
Yes,
Clause
that is
47 and Rule 47, all the grounds,
yes.
all the 3 grounds.
Then, my lord, yes, your lordship may kindly see the grounds, my lord. Grounds start from page 8, my lord.
Yes, please.
Yes. Ground number 1, quoted in the cross-examination DW3, so and so, before the Foreigners Tribunal for Hazu, he categorically deposed that father of the proceeding was engaged as a laborer in his house about 5 years during 1976-81. On the other hand, if Exhibit D, voter list of 1996, age of Abdul Jalil, that is the father of the proceedings considered, therein his age is shown to be 40 years and accordingly, he attained majority in the year 1975. That is minus 3. Further Exhibit E and F, that is the voter list of 1966 and 1970 Taleb Ali, and Exhibit D, that is the voter list of Abdul Jalil alias Abdul Jalil, when considered together, it reveals that Abdul Jalil is the son of Taleb Ali, or simply Taleb. The same exhibit also clarifies that in the year 1966, Abdul Jalil was only 9 years. 1997, 40 years, hence 97 minus 96. This is calculated this, my lord. Then, hence the question of joint name of Taleb Ali and Abdul Jalil during 1966 voter list does not arise. Again, in the 1970, Abdul Jalil was 13 years since 1997. So 97 minus 97, 27 years ago. Therefore, they are showing it was 13 years. Hence, during that time, in 1997, the joint name of the Taleb Ali and Abdul Jalil does not arise in the voter list. In either case, the Abdul Jalil was minor. Upon the following three metrics, as he have appeared herein above, as have appeared herein above, from exhibit E, F, D are overlooked and remain unconsidered by the Honorable Court in earlier occasion. This is not true, my lord.
Currently not true.
Yes.
Then
For the learned tribunal during cross-examination DW4, that is father of the proceeding, had noted down that DW4 would produce the cell deed before the tribunal by the following date, but it remained remained surrounded in mystery. Further, the learned tribunal, upon the deposition of the proceeding, has rightly determined the year of SIP by her grandparent during 1976, that is year of deposition from so and so. So 1976 he shifted. Now, if Taleb Ali shifted from Bangalpara to Niskaurbaha during the year 1976, then the list of 1966-70 has the justification that Taleb Ali and his family were at Bangalpara and shifted in 1976 to is justified for and Abdul Jalil's family tree pending has been clarified by Exhibit D, that is voter list of 1997. Another aspect is that in the intervening period from 1970 to 76, the family of the Taleb Ali had been staying in Bangalpara, that is till 1975, and during those periods, Abdul Jalil attained majority in 1975, and in such intervening period, whether there was any preparation of electoral rule of 61 number Haju LSE, or it might not have taken place, and for the preparation of SIP place, and for those reasons, no name of Abdul Jalil with the parents is marked. Whether Taleb Ali died after a few span of years or SIP, when there is a clear reflection in the appreciation of evidence in record by the learned tribunal at to court, the reason as to why the proceeding has not submitted the voter list of of her grandfather after 1970 cannot be clearly understood. Although it is crystal clear that the father of the proceeding got his voting right since 1975. This has nothing to do, my lord.
no, that was not a clear case before.
Yes,
the
that
trial.
was a clear case. So it is a clear case.
That was
then
not
my
a
lord-
pleaded case before the.
Yes.
It was
Quoted the
clearly
Honorable Court.
stated.
Yes. Quoted Honorable Court has taken into account the deposition of DW4, father of the proceeding, petitioner applicant, and DW1, that is the proceeding petitioner applicant, that is claiming the order to be father and
Now,
daughter of
come to
relations.
page number 21. Which the petitioner did not read.
21, my lord.
Yeah.
DW3 portion.
There are
From the first oral and evidence.
yes, please read.
Yes, from the opposite oral evidence, the fact that the grandfather and his family of the petitioner might have migrated from village Bangalpara to village Niskaurbaha 40 years back cannot be held to be proof on the face of the contradiction of the said witnesses referred herein above. The submission of Mr. Soka that the oral evidence remains unrebutted cannot be accepted in as much as when there are contradictions amongst the witnesses produced by the petitioner and their variants are recorded, yes, versions are recorded, the same form part of the evidence of the petition put on record in order to discharge the onus probandi consistent with the fact in issue. This is because of the fact that the said witness were called by the petitioner.
This is called by the petitioner.
Yes, called by the petitioner. Proceeding to prove the facts which are within her special knowledge, and once there is a crack in the said evidence, the projection of the petitioner is bound to fail. That is the
Hereafter this analysis.
yes,
Now the only ground of the review petition that is that particular, there is no link established. With.
yes,
That is one of the findings.
that is one.
But the court, while considering this matter and rejecting the case of the petitioner, have also considered the evidence of the witnesses examined.
All the witnesses, my lord. All
So
the
you have to read the judgment as a whole from this particular last paragraph of page 21. That is the main finding.
yes,
In addition to that, there is a line that there is no link established.
yes, ma'am. So there is no link as well. So, my lord, my submission is that, my lord, in fact, those are matter of evidence. We may not go to that aspect also. Here, the main question is he could not establish, my lord, he could not brought anything that there is an error apparent on the face of the record in the opinion, in the judgment. Next, my lord, he has brought 2-3 evidences, my lord, documents before the honorable court. These are not part in the, my lord, these are not brought as a ground for review. He has just annexed this, my lord, exhibit annexer K and L. These are not, my lord, taken as ground for review, that these documents we could not produce in the tribunal or in the High Court at the time of writ jurisdiction, writ petition, filing writ petition, even after due diligence. My lord, even though new documents, new evidences are collected, new evidences, new documents has come out, but that has to be, my lord, in review jurisdiction, one thing has to be clear, that there was a due diligence on the part of the petitioner or the proceeding to find out those documents or those facts. And even after due diligence, they failed to produce those documents in the tribunal, all in the, my lord, writ court. But that is not a single statement.
Whether the voter list of 1993, whether the school certificate, or the
This is personal knowledge of the petitioner. If these documents were existed at that time, she should know, because these are her personal documents, madam. And there is not a single statement that there was a due diligence. There was due diligence on the part of them, or they tried to brought out these documents. In fact, these are not a ground. These are not in the ground. They have not taken these documents as a ground for review. They have just annexed, my lord. Your lordship may kindly see para 14, they have stated in the review petition that additional documents, those are slipped off and ignored at the first instance, are annexed here to for kind perusal and consideration. So this was slipped off or ignored at the, this is not the ground. This cannot be, in fact, this was not it. This is just an statement. So those are annexed here. Even they have not prayed that these documents may be considered for ground for review. The grounds put by the petitioner, review petitioner, is old and same argument which was there in the writ petition. These were taken, considered. After consideration, it was rejected, and review jurisdiction, it cannot be reopened in the review jurisdiction. Would it, whether review jurisdiction, what is under these two judgments maybe kindly, maybe, my lord, not done.
To come to
Did-
that. But an affidavit was filed by the writ petition. In the writ petition, you have in the writ petition copy you see, it was filed on 18th of November 2016. Not 18 November. It was 19th of July 2008. Wherein the voter list of 1993 was the next.
My lord, my submission is that even though 1993 comes, my lord, it has no relevance at all. Because 93 is a post 1971 document. And 93, the petitioner, the father and the grandfather is not a common voter.
What the court found is that shifting after 1970 not true. Yes, what is the judgment you want to say?
The affidavit, my lord, annexure 19 of the writ petition.
Anyway, which is the judgment?
My lord, two judgments, my lord, that is, one is, my lord, that is 2013 8 SCC 320.
And
320. There are 20.1 and 20.2, my lord. This should do. Which, and then, my lord, another one is 2022 SCC online SC 1034.
2022
Yes, my lord. SCC,
2020.
yes, 2022, my lord.
Hmm.
2022 SCC online SC 1034.
What is party's name?
Party's name is S. Madhusudan Reddy versus D. Narayanan Reddy and others. Earlier one was Kamalesh Verma, my lord. So this, my submission is that, my lord, this review is not maintainable for lack of any ground in itself, my lord. That's only. Obliged.
Any reply you want to?
Lordship, I have to submit only one thing. Lordship, kindly consider whether the proceeding is the starter of Abdul Jalil from the evidence WS of all the lower court records.
See,
whatever.
basically everything is fine.
And from the
there is-
evidence
you
of
might have
Abdul
known that the procedure is the daughter of Abdul
Jalil.
Jalil.
And the next is whether
But
any of
Abdul Jalil of News Baha and Nikaur Baha and the Abdul Jalil of Bangalpara, there is a difference because there is no Abdul Jalil in Bangalpara. There is only Taheb Ali. So there is no proof that the Abdul Jalil son of Taheb of village News Baha is the same person of Taheb Ali of Bangalpara. Where is that finding? That is why the court in the previous page, at page 21, have clearly laid.
so in that respect, we submit additional affidavit to establish the relationship between Abdul Jalil and Taheb Ali. Taleb Ali.
How you have
Certifying to village headman certificate.
That will not help you. The village headman was 70 years old when he deposed.
This is
He was
another village
24
headman.
years in the year 1970, and he did not see the grandparents of the proceeding. He was the village headman of News Baha.
News
He did
Karwa.
not see the grandparents of the proceeding. Anything else?
Lordship, the next is whether additional document, additional evidence support filing in the review application is permitted to be consideration or not.
We will
In-
look into it.
In this regard, I am placing one judgment. 2014 14 STC 77,
2014, 14 SCC,
77.
okay. And
And this judgment only, paragraph 22,
para 20,
paragraph 22. I have a copy, I can supply.
20 give us. Like a heart Mr. B. Council for the. And Mr. Devan, and the council. on the- Yes, Mr. Majumdar.
We were required to file our affidavits, but the admission session is still on, my lord. So the complete report has not come. However, my lord, I'm getting those two from the Secretary of Elementary Education. And my lord, another single sheet I have given. One single sheet, my lord, I have given one instruction. Here, lordship will find with reference to subjects that I will submit here with report on the status of implementation of so and so during admission session for the academic session 2025 in the unaided so and so. Copy encloses an extra. That was 174 pages, my lord. I have given it on mail. Perhaps it can be seen on the screen.
174
pages for the secondary education, my lord. So there, what they have done is they have given it school wise, the number of students who have been admitted, the percentage which has been covered, the minority schools which are not required to take in those persons, that has come from the secondary education to some extent. But the actual number of students who would have been admitted, how many had actually applied and how many have been taken in on the post, that clarification did not come. If lordship will have the other bunch that I have given, my lord, that was from the elementary education department. Here, my lord, the last paragraph, lordship will see, second last paragraph, my lord. With regard to the status of launch of portal for effective implementation of the said section of the RTE Act 2009, it may be said that the cabinet deferred the proposal with the direction that the same will be discussed after the model code of conduct of ensuing election is over. And if lordship will kindly have the fifth page, my lord, where that table is given, chart form is given, my lord. Now here, lordship, this is what has come from the elementary education from the districts. Now, lordship would find that if we just take Borpeta for a moment, my lord, Borpeta, name of the block is Borpeta, number of aided non-minority school of special category 17. Number of non-aided category compliant 12, one is shown to be 0. Number of unaided minority school against 0.5 enlisted is said not available. So now, my lord, these districts, they did not give us the specific information as to whether applications were not received or admissions were not given by the particular school.
Whether the DIs and the DU
My lord,
have issued any such order to collect is from these respective schools.
yes, my lord. Then lordship will have that first page again, my lord, the second paragraph. However, the said report gives a partial picture of the number of children admitted in the unaided minority schools in the schools of special category in each district under section 12(1)(c) during the current academic session 24-25. To give a clear picture of the status of implementation, the Department of School Education is going to collect a comprehensive report from each district to the Director Elementary Education, for which at least 4 weeks time is sought, as admission process is still not completed in certain schools in different districts. Even, my lord, the school in which my children, my lord, they study, the admission has not even started now. It is going to start day after tomorrow. So there are some difficulties where these, in a hurry to comply with the order of the Honorable Court, my lord, they sent us whatever details they had. This is not, this will not form a comprehensive affidavit. Once the admission process is over, my lord, we can get the entire details school-wise. So therefore, my lord, perhaps this lordship will find was signed yesterday. Till yesterday night we tried, my lord. If you could get the comprehensive. One is from the secondary education, that lordship will find the one pager with, my lord, 172 pages report that report must more mail ka disilu. Sort of 172 pages. Eta mail gese. যদি সাটা লসিপটা খুলিব পাই তেতিয়াহলে মই তাত দেখাই দিব পাৰিলো।
May it please the lordships, the petitioners have not been served with this email. I have no records of this email.
This was an instruction to me. The affidavit, once we bring it on record, they'll get all the documents.
may it please your lordships. Lordships, in this PIL, there were certain broad areas that the Honorable Court had highlighted in the PIL for effective implementation of Section 12(1)(c) of the RT Lordships. First was regarding admissions. In the last year when the PIL was instituted, Lordships, we had brought in instances where children whose parents had gone to these schools, the principals or the staff members had rejected the applications and rejected the parents to even enter the schools on the pretext that there was no official notification from the state government, Lordship. And it was only after the directions of the Honorable Court that the admissions took place. Now, with regards to the implementation, Lordship, the Assam government had, in our earlier PIL, Lordship, I had filed it, and the office memorandum was released, where a clear demarcation of the rules for the state were highlighted. Here, Lordship, if I may take Lordship's attention to page serial number 43 of the paper book, Lordship. The office memorandum, here,
Yes.
Lordships, in the activity calendar in the table, Lordships. So the idea is that the admissions were supposed to take place last year by 1st of April. And after that, 28th May, the names of the admitted children were supposed to be uploaded in the department website, Lordship. For the last year, we have been requesting the state to upload the names of children who were admitted last year. We still have no records. In fact, till yesterday and today morning also, when I checked the Department of Education's Assam government's website, there is no information regarding the children who were admitted till last year. Next is, Lordship, with regards to the same children. If we come to page number 44, Lordship, of the OM, here Part D mentions that there has to be a quarterly inspection by the Education Department of all the schools where children who are admitted under RT 12(1)(c) are studying. So that number one, there is no discrimination. Number two, there is no segregation between the children, between the fee-paying children and the children admitted under the 12(1)(c) provision. And also to make sure their learning outcomes are equal or parallel to the ones who are paying the fees, Lordship. We still don't have any records of the children who have admitted, only the 44 children who sought admission through the Honorable Court's intervention. Those details I can peruse from our petitioner's paper book and maybe orders of the court. But apart from that, there's no public record of any other children who were admitted, Lordship. Now, that is the first part. The second part, Lordship, was that given the fact that we had seen that last year, many schools had rejected the parents to even enter the school and seek admission form and even inquire. That is why NCPCR, when this problem was taken up, NCPCR had released a standard operating procedure, Lordship, to be implemented by all state governments for implementation of 12(1)(c), Lordship. So in the NCPCR SOP, Lordship, it was clearly said that the admissions is supposed to be taking place through a centralized admission portal. And this is a portal we have been harping since last year. The last year, the portal was not made, which is why through the Honorable Court's intervention on a case-by-case basis, the admissions took place. And for this admission year, we have been waiting since last year after dates after date that the admission portal will be out. The portal meaning that there's a call for applications where the parents can apply. Even yesterday, when I was speaking to certain parents, we still don't have any portal. It is being deferred months after months. And again, 1st April was the date when the admissions were supposed to take place. And not many parents still know about the portal or know about this provision itself because there is no announcement of the state. There is no admission announcement and the portal being set up as of date, Lordship. And all of this that I'm saying is in the office memorandum of the government of Assam and also in the statement of the SOP, standard operating procedure by NCPCR, that was again directed by the Supreme Court to be implemented across all states for implementation of 12(1)(c), Lordship.
Have you received any complaint from any parents that some students from this particular category, their admissions have been rejected throughout Assam under 12(1)(c)?
Lordship, yes, precisely.
How
When
many such applications you have were aware of that it has been rejected by the school authority
this year, Lordship, or the previous year?
from the time you have filed this PI?
From
How
the
many
pri-
such cases were there before you?
Lordships, we had in our admission campaign, we had supported 49 children, Lordship, out
No,
of
These admissions are not given. What is the duty of the parents? Why they have to approach?
so the parents have to ideally first approach the school, and when the schools did not support the parents in terms of admission, Lordship, they were not able to.
Objected to that.
The next is approach to the district elementary education officers, Lordship. And when there were some representations filed with the DEOs, there was
Whether those parents will be able to show that they have approached, they have obtained the application forms.
yes, Lordship. So again,
Specific years where you are dealing with,
sorry, Lordship.
will able to they show the application forms that they have obtained for that particular year on which the school authorities have rejected their applications.
Yes, Lordship. So as per the, again, firstly, the applications form, Lordship, most of the schools did not even have a standard application form outlining as per the requirements of
Particular schools you are talking about.
the respondent schools, Lordship.
These kind of schools which are running, managing without the aids of the government, they doesn't have any application forms.
The Lordship,
Correct.
the application forms which are applicable for the fee-paying children, Lordship, and application forms for section 12(1)(c).
For any student to be admitted in a school, there has to be an application form, whether to be paid by or not unpaid, right?
Right, Lordship.
Now, when did these parents procure those applications?
Applications were procured last year, Lordship, around
So what is the number of that application? Because every time when there is a school application to be obtained, there is no mention that only it is free admission, right? That means at the time of admission, there will not be any fees will be paid by the parents of these children. Is there any mention that when for obtaining these applications will also be provided at free?
yes, Lordship.
She doesn't say anything as such. They say it's only free admission.
If I may,
Yes, read 12(1)(c), read it 2 and 1 and 2, or 4 and 3 and 4.
Lordship. Lordship, I'm reading section. Lordship, in section 12(1)(c), Lordship, the Parent Act itself mentions that extent of schools' responsibility for free and compulsory education for the purpose of this act, a school, again going to section 12(1)(c) here, specified in subclauses 3 and 4 of section 2(n) of section 2, which is specified category schools, Lordship, and private unaided schools, Lordship, shall admit in class 1 to the extent of at least 25% of the strength of that class, children belonging to weaker section and disadvantaged group in the neighborhood, and provide free and compulsory education till its completion, Lordship. That is till class 8, Lordship. Now, Lordship, because after this implementation,
Kindly indicate the number of percentage each of such schools have rejected to those kind of students. First of all, you have to establish how many such students have applied for in those particular schools.
Lordship, last year we had the petition when this
Which
petition.
particular district?
Sorry, Lordship. This is last year, Lordship. We had filed admissions.
District.
Lordships, Kamrup Metro, Kamrup Rural, and Nagaon districts, Lordship. And the school.
How many schools are there in the Kamrup Metro of that church category?
Sir, Lordship, as per government records, there is no mention of the number of schools recognized, but approximately there should be close to 7,000 to 8,000, Lordship, schools in Kamrup Metro, private unaided schools, Lordship.
How many is there in Kamrup Metro in Guwahati city?
Lordship, that official data is supposed to be updated by the state education.
How many schools you have approached?
Lordship, we have approached close to 15 schools. Our parents had reached out to close to 15, 20 schools, Lordship.
whether have now the parents have complained it to you or complained to government authorities today?
Lordship, they had complained because we were also involved in supporting the parents in filing the applications. We had been informed, Lordship.
Who was that those applications were rejected by those school authorities?
Lordship, those applications,
Read petition?
yes, Lordship. It was in last year itself, the applications which were rejected, Lordship, were annexed with the petition. And later on, the Honorable Court had taken cognizance of it. And after intervention of the court, the admissions were granted, Lordship. This was last year, and all admissions are done, Lordship, for that. But it was only after intervention of Honorable Court that the admissions.
What about this year? This PIL is of 2023. For the 2023-24, how many applications were rejected?
Lordship, right now we are not actively campaigning for this, but I have yesterday spoken to close to 5-6 parents, and their applications are still yet to be considered, Lordship, because there are still schools which say that since there is no official notification from the state government, we don't know how to proceed. That is what is told. And Lordship, in the PIL itself, the assurance given by the State Education Department was that so that the schools and the parents don't have to face this issue this year, there will be an admission portal, an online portal where if let's say I want to admit process an application for my ward, I can apply through the online portal, Lordship. And the portal, then the State Education Department can scrutinize my application and directly inform the school. So then there is no rejection problem that we encountered last time. This can be avoided, Lordship. And such similar admission portal is existing in multiple states, Lordship. And we have mentioned that in our petition as well.
Okay.
It's such as Uttarakhand, Uttar Pradesh, Chandigarh, Rajasthan, Gujarat, Madhya Pradesh, Chhattisgarh, Tamil Nadu, Andhra Pradesh, Odisha, and Maharashtra, Lordship. At the time of filing of this petition, which is mentioned in page number 23, Lordship, of this PIL, paragraph 22, these states have centralized admission portal, Lordship. So directly the admissions take place, which is why the number of beneficiaries of this provision is also very high in these states, Lordship.
Please come to page number 44.
Lordship. Lordship.
Part D, monitoring and grievance redress.
Lordship.
2.
Part 2, grievance redressal. Existing grievance redressal notified by the additional chief secretary to the government of Assam wide number so-and-so dated Dispur 18 September 2014 will be followed. But in particular, if any irregularities are noticed during the process of admission and imparting education, the parent may intimate the block elementary education officer in writing.
How many objections you have filed or you have intimated to how many block elementary education officers in writing?
Lordship, all the applications for the last year.
Which are the block elementary education officers? We are talking about 23-24 and 24-25.
Yes, for 2024, Lordship, all the applications when they were denied, where there was a letter written by the parents attesting the application form which was not accepted or rejected, were all sent to the block, the That time, the district elementary education officers directly, Lordship. And since there was no action taken, then the Honorable Court intervened,
Come to page number 41.
Lordship. Lordship.
Part B1.
Part B1. The unaided non-minority private school shall display the total number of free seats available at the entry level, date of issuance of admission forms, submission of filled in admission forms, and a form for admission of against free seats, date of lottery, date of display of eligible applications, last date of admission form on notice board of the school by 10th March of every year, Lordship. Last year, no school complied with it, Lordship.
It is because the 10th month, because now the schools having the sense, some of the schools are only in April they are doing it.
Lordship, and the reason when the parents had gone to
Read Sri, part B.
Part B3. The State Education Department shall officially announce about the issuance of admission forms under Section 12(1)(c) through website, regional newspapers, and reliable media. The application forms will be received free of cost from respective schools, and filled in applications be submitted to respective schools alongside requisite testimonials. School will design application form as per the rules, incorporating the information specifically: name of child, parent details, date of birth, Aadhaar card, contact number, caste, so and so. Lordship, when this was not implemented last year, a PIL number 24/2023 was filed by the same petitioners, and that time, through the Honorable Court's intervention, the admissions are officially.
Now this is operating, right?
Lordship.
After the order of the court, this
This was done last year, Lordship.
of this admission procedure of part B is now been implemented. That is
Lordship,
April.
implemented last year. If I may, Lordship, this was implemented last year in the earlier PI. And this year, because this announcement is supposed to be done every year as per the OM, as I have mentioned in the activity calendar that's been given. Last year, Lordship, after the intervention of the Honorable Court, this was the admissions were announced. Yet certain schools had not, taken cognizance of that particular announcement, and then this PIL was filed because the schools had not implemented.
Yes,
And-
Mr. Panda, what do you have to say? on
My
this?
lord,
What about 2024, 24, 25?
Well, the difficulty is when they say certain parents, certain schools, it is difficult for us also to identify unless something comes into us directly from somewhere. That this is the school, this is the parent. Nothing comes to us. Lordship will find several of the affidavits filed on when the issue was taken up last year. Parents had not approached the school, they had approached only the petitioners herein, perhaps. Then there were cases where the children were not even entitled to be given that free admission under the RT, but the schools gave them under the RT because
What controls
Of-
you have this particular schools which are unaided schools?
well, our control is under the Assam Non-Government Educational Institutions Act,
Whether
that one,
these
and
schools
this-
have been registered under
Well, the registration has been
1996 Act?
has been stayed by the provision of registration of everybody requiring to register under has been stayed by this Honorable Court in the Delhi Public School matter, my lord. There is a
Lordship.
stay. Those who want to register with us can of
RTs,
course register.
Lordship.
Those who do not want to do so are exempted because of the stay orders of this
Now,
Honorable
what
Court.
kind of control?
They have
the
also filed a
government will
PIL on
have
that
over
regard.
These kind of schools,
My lord,
they are registered or not registered?
my lord, once they do not, if we find that they have not complied with the rigors, my lord, the provisions are given in the right to education itself, and we can also go for the recognition or closure of the school, even we can go for it. And
And
there, on the last occasion, my lord, when we found that one or two schools had indeed taken the fees, they had admitted before this Honorable Court that they took the fees. We had given them they were taken to task and ultimately they refunded the fees and the matter was left at that because the fate of all the other students in that particular school would also depend on the action that we take on that particular school because of not admitting one child. This year, my lord, there has been no written complaint as of date to any official saying that this is the person who wanted an admission or this school is not giving us a admission form, or that this school has refused us any admission at all. Now, if Lordship will kindly see under the Act, the liability is only for class 1.
No, that is true, but they have to complete it up to class 8.
My lord, now when they ask for fresh admissions in class 2 or class 3, it
primary.
is difficult for us to
Sir,
even
Procedure only for class 1.
only for class
The
1.
act
So now,
itself says class 1.
if Lordship will kindly have the PIL at the first go, my lord, the particulars of the students whom they say were not being given the admissions, Lordship will at page 63. And all the students have been given the admission. We ensure
because it is before the court, because it's a PL, because it is education. Page 63, Lordship will find. The first person, class 2. Second, class 7. Third, class 4. Fourth, class 4. Fifth, class 5. Sixth, class 5. Seventh, class 6. Eighth, class 6. Then, ninth, when they say that this is the Pathajit Thakuria, my lord, an affidavit has been given by the school saying that this person has informed the school in writing that he never applied for the school. That name is here. Then Lordship will find number 10. Shubham Day, class 6, then class 6, then class 6. Next page, class 6, class 7, class 7, class 4, class 2, class 7. One is again KG, never applied for the affidavit of the school. Then serial number 20, class 4, 21, class 4, 22, class 2, 23 is UKG. So we are doing our best. Let's take
Lordship, if I may, Lordship.
Just a minute. Chapter 4 of Right of Children to Free and Compulsory Education Act 2009. Consisting of sections 12 to 28. Relates to responsibilities of school and teachers. Say 2009 Act relates to or provides for it. Extent of school's responsibility for free and compulsory education. Section 12, within bracket numerical 1, within bracket small c, stipulates the script criteria that are provided to us. The section 2 of the 2009 Act noted above relates to definitions. Where section 2 and small n within bracket reads as follows. Section 12, 1C of say 2009 specifically provides for admission in class 1.
Lordship, Lordship, the proviso right after that says that if a school has a pre-primary section, the 12(1)(c) provision will apply in the first.
Already noted down. And the proviso to said section also clarify the admission to preschool classes wherever such classes are available. Section 12(1)(c) as well as its proviso also clarifies that once an admission is made either in class 1 or in pre-primary classes were available, the students admitted under that category should be provided with free and compulsory elementary education till its completion, i.e. up to class 8 as per the SEC 2009. The state government in its office memorandum number PMA 73/2021/47 dated 22nd 02/09/2021 that relates to guideline for implementation of section 12.1.c under Right of Children to Free and Compulsory Education Act 2009 in the state of Assam. At its Part C, Part D. Yes, people have written colon likhita. Monitoring and grievance redressal. In clause 2, specifically provided that if any irregularities are noticed during the process of admission and imparting education, the parent may intimate the respective block elementary education officer in writing. Mr. Muzumdar Lalit, Training Council for the Department of School Education on instruction submitted that during the year 23-24, 2023-24, during the admission era, admission period of 2023-24 in elementary schools related to class 1 or pre-primary class. The elementary education department did not receive any such objection from the concerned block elementary education officers. With regard to rejection of admission class 1, the categories of children specified in clause section 12.1.c of SEC. Next, Mr. Muzumdar also submitted that the admission class 1 or pre-primary class, such unaided school still going on, yet to be reported. On instruction from the Secretary Government of Assam in the Department of School Education dated 01/04/2024 pertaining to this PIL. Mr. Mazumdar submitted that today a virtual meeting has been scheduled with all the inspector of schools, the district elementary education officers for an elaborate discussion in respect and ensure to ensure the submission of comprehensive reports regarding the admission as provided under section 12.1.c. This is 2009 Act. 14 packet 1, 14 packet small. Mr. Mazumdar also submit that there is a dedicated portal in the Department of School Education for effective implementation of section 12, implementation of the provisions of section 12 within bracket 1 within bracket small c. It's 2009 Act. And that such portal will come into effect after the ensuing parliamentary election is over. As per the decision of the cabinet. Stating that presently the model code of conduct to election is enforced. Mr. Mazumdar also placed a communication of the Secretary of the Department of the Director of Elementary Education, SAM, whereby all the district elementary education officers the district primary education officers have been asked to fill out the respective format, specified format with regard to admission to the students to the category of 12 in bracket 1 within bracket small c of state 2009 Act. Communicated to all the concerned authorities on 7th of February 2024. And report from such authority is awaited. Considering that the admissions in some of the unaided non-minority schools still pending. Place this matter again on 2nd of May, enabling the authorities in the school department or the school education department to place the up-to-date status regarding the admission of students in such unaided and non-minority schools in the state of Assam as per section 12 in bracket 1 in bracket small c. Application.
Lordship, just one request.
Yes.
Lordship, the thing is that because the portal that the Assam government is supposed to have for implementation, Lordship, I have just checked it right now. It doesn't exist, Lordship.
It
If
will
we-
be,
and the
will
thing
be
is,
available only after the
And-
election is
The
over.
Lordship, most schools also start their admission, like their
If
academic.
any parents are having any objection, they can always make it to the block elementary education officers as per that office memorandum we have already made. And by the time we'll come to know in the month of May, 2nd of May.
Lordship. My only contention was that there would be two class of children one who would join later after the portal is set up once they start their.
If any parents have any grievances, they have their own things, they can approach the concerned BU.
Lordship.
Let us see how many parents approach.
May I make one prayer, my lord? Could it be on the third, my lord? I may not reach
You'll
here
not
on
be
the
able-
second. On the
Fine.
third. my lord.
We'll have it on 7th of May.
Second.
Seventh will be holiday.
Huh?
The
Oh,
7th of May of election.
Election.
Oh, yes.
8th of May, Lord.
We'll have it on 9th of
9th.
9th May is
9th.
14 day. It's a Tuesday.
Thursday.
Thursday,
9th is a Thursday.
9th.
I'm so obliged.